I will now call the case of State of Kansas versus Efrain Arroyo, case number 128013. You may proceed.
It looked like you were organizing, and I wanted to make sure you were ready.
But go ahead.
Okay.
Thank you.
May it please the court, Kristen Patty, counsel for the appellant, Efrain Arroyo. Nobody really knows what happened for about at least 3 hours, fairly, a little before sunrise, on a morning around Thanksgiving in 2019. Mr. Arroyo's body, or Mr. Hernandez's body, was discovered at about 7:15, and he really wasn't seen since about 3:26 a.m. when he's shown on video. There is a place where he might have been one of the parties that we can't really view on some home security video at 4:18 a.m. But other than that, we don't know what happened. Mr. Arroyo was convicted of Mr. Hernandez's murder and some other charges mostly based on the testimony of 3 felons who all had convictions for dishonesty or false statement. 2 got promises of immunity. 2, including one of the first ones, got promises of probation. And I know we don't really, need to go into the facts quite as much as we have had in previous years. But with both of the arguments that Mr. Arroyo raises in this appeal, we have one where certainly this court would have to find that the error, if there is any error, was harmless. And then the other, of course, is we're talking about lesser included instructions and whether the jury might have found, there was a reasonable possibility that the jury might have found that one of these other lesser included offenses would have been the verdict if those instructions had been given. The first point of error is a statement that the prosecutor made in a rebuttal closing, which is, if there's a piece of evidence they want you to see or a witness they think you should hear from that helps their cause, they have just as much opportunity to put that before you as we did. And Mr. Arroyo argues that that was a direct and unequivocal comment on his failure to testify or otherwise present any evidence in his defense. That it also sought to penalize him in the eyes of the jury for exercising his right to a jury trial. And it suggested that he had to disprove the prosecution's case. I know that my colleague will get up and talk about how it comes within the wide latitude that prosecutors are afforded to discuss the evidence. But again, Mr. Arroyo submits that that was not harmless, and that his conviction should be reversed because of that. The other point of error is that Mr. Hernandez's body had some abrasions and contusions that were relatively minor compared to the gunshots that killed him. And I didn't mention it first, but they tested the slugs that and the cartridges that were found around his body and the slugs taken from him, and they didn't match any of the guns, either of the 2 guns that were found. One was found in an attic of someone else's home, and the other one was found in Mr. Arroyo's constructive possession at around the around the time of his arrest. Because of those minor abrasions, the jury could have found that, first of all, if they had been given an instruction on kidnapping, which was legally appropriate because legal kidnapping is a lesser included offense of aggravated kidnapping, that those would be, are trivial injuries that don't count as bodily harm and that therefore can support a kidnapping conviction rather than aggravated. The other lesser included that Mr. Arroyo requested was for criminal restraint. One of the things that is perplexing about this case is whenever we do see Mr. Hernandez on this home security video, he's not like he's being ordered around with a gun. He seems to be there willingly. And we can't really tell that there was any force or threat from what we were able to see. Even one detective admitted that if any time Mr. Hernandez had wanted to flee, he would have been able to do so. And so therefore, Mr. Arroyo requested at trial the lesser included of criminal restraint because his liberty was not by force of threat, any restraint. And therefore it would have been factually appropriate. I think this is only the second time that I've been before you and not seemed to be getting a single question. That time was on a Friday, and I think at that point you guys were all glazed over. At the end of a long week's docket. If there are no questions for me, then I think I will pass it off to my colleague.
Any questions? Thank you, Ms. Patty.
Thank you.
Thank you. You may proceed.
May it please the court, Assistant District Attorney Christy Allen appears on behalf of the state of Kansas. As opposing counsel mentioned, there are three issues that were briefed. Getting right into the prosecutorial error, my colleague is right. The standard of review is a two-step process. Did error occur, which given the wide latitude afforded to prosecutors to attempt to attain a conviction in a manner that does not offend the defendant's constitutional right to a fair trial. I would remind this court that this court also looks at comments made in their full context. So what my colleague has quoted to you today is just a portion of the closing argument that was made. And I would also note for this court that that comment was made in rebuttal after defense counsel made numerous inferences that the state had failed to meet its burden of proof because they didn't admit certain exhibits, they didn't present certain witnesses, and therefore that the state had not met its reasonable doubt burden of proof because there were things missing. And therefore the prosecutor stated in rebuttal in whole, I want to make something perfectly clear. It is our burden. It never shifts to the defendant. But do not be misled for a moment that if there is a piece of evidence they want you to see or a witness they think you should hear from that helps their cause, they have just as much opportunity to put that before you as we do. So don't be misled by that. She continued with, now rather than look over here and look over here and over here, how about we look at the evidence in this case? How about we look at the testimony in this case? This court has held on numerous occasions that the state is permitted to rebut an inference that the state is not credible or has not met their burden by pointing out that the defendant has the same ability to subpoena witnesses and to admit evidence in this case. So therefore, I would ask this court to find that in the complete context of the prosecutor's closing statements, that there was no prosecutorial error. However, if this court should find that there was error, the state would submit that it is harmless error. For harmless error, this court would apply the traditional constitutional harmless inquiry that the state must demonstrate beyond a reasonable doubt that the error complained of did not affect the outcome of the trial in light of the entire record. And I will submit to this court that in light of this record, this court should find that there was no reasonable possibility that the error contributed to the verdict. if this court will allow, I'll go right into the jury instruction issue because that also has a harmless aspect to it. Because in this case, yes, the defendant did request the 2 lesser included jury instructions. They were legally and factually appropriate. However, the state submits that it was harmless error for the court to not provide that jury instruction because there was no reasonable probability that the error affected the trial's outcome in light of the entire record. So what we have here is we have a defendant who is angry at the victim for potentially selling a truck that he has. He gets a friend or an acquaintance to go pick up the victim. He then confronts the victim, holds a gun, a handgun, to the back of the victim's head. He then drives around. This doesn't just last for a few minutes. This lasts over a period of hours. He drives around with the victim. At one point, he tells a witness, if he did sell the truck, I'm going to kill him. At another point in time, we have testimony that the defendant asks to go to his parents' garage where the victim gets on his knees at that point. A rope is then bound around the victim's waist. Then the victim is found hours later face down in the dirt with his hands tied behind his back with the same rope with 4 gunshot wounds to the back of his head. And there are 5 spots on the rope where the defendant cannot be excluded as the contributor of that DNA. So based on this evidence, the state would submit that there was overwhelming evidence that any error that was made was harmless. Furthermore, my opposing counsel did brief cumulative error. However, the state would submit because it was not error that by the prosecutor for her rebuttal closing statements, that only one error cannot reach cumulative error. The state would ask this court to find that there were no errors and affirm the defendant's convictions.
Any questions, colleagues? Thank you very much.
Thank you so much.
Ms. Patty, you reserve 3 minutes.
Yes, I did. Since there's weren't any questions for either of us, I guess again, I would, I didn't address the cumulative error because certainly you have to find 2 at least. And I understand also that the laws somewhat changed, but I'm probably going to at least ask for cumulative error as long as I can. Don't forget that one of these witnesses was granted immunity during the middle of his testimony over the lunch hour. So if the state really thought that it had that strong of a case, they wouldn't have needed to do that. And since there are still no questions for me, I will stand on the brief and I would ask you to reverse Mr. Arroyo's convictions and grant him a new trial. Thank you.
Let me help you.
Yes, sir.
That way you can justify your trip. On the lesser included, it seems to me that the council's argument is that for the jury to have convicted on that requested count, they would have had to ignore all the evidence about your client being involved with confining the victim, tying the victim up, the lacerations, and they would have had to say that his involvement ended before any of that happened. Is that right? That's the way I took the argument.
Yeah, I think probably so. You know, there's at least the 3-hour time window beginning at 4:18 and maybe even backing up to 3:20.
So what's the reasonable possibility that that's going to happen under this record?
You know, I have a job to do. And it's what I was given from the record, what my trial counsel created for me. You know, there's always the idea of if they had another possibility, would they have done it? And there's certainly, as we talked about with the lesser included, there certainly is, it's both factually appropriate and legally appropriate. Thank you very much.
Any further questions, colleagues? Thank you, Ms. Patty. Thank you, counsel, for your arguments this morning. Court will be in recess until 9 a.m. tomorrow morning.